Dear friends, I'm Homi Bhabha, Director of the Mahindra Humanities Center. And before I give my brief remarks, can I ask you to do something with me and for me? Take this thing in your hands. Usually people think that it's a kind of mind-body problem, that they can keep thinking about it and they don't. Get this out and switch it off now. Please switch it off now, because I know just how easy it is not to switch it off. Thank you so much. Thank you. As director of the Mahindra Humanities Center, my colleagues and I are deeply privileged to welcome you this morning. This is a profound moment of recollection as we formulate our proposals for reparations. Humanists love complexity, and we are abused for it, mostly. But what could be more complex than the situation in which we find ourselves today? This is an occasion on which we aim to translate the incalculable harms of history: death, violence, violation, discrimination, humiliation, into the compensatory goods of reparations that demand legal, ethical, economic, and political justice. The struggle for reparations is founded on death, whether it is physical death or social death, and grounded in the intergenerational trauma of memory. And death and memory are human conditions for which there can be no adequate reparations. There can only be reconciliation. And they are not the same things. As we struggle for reparations, let us acknowledge the different and difficult task of reconciliation. This is one of those complex moments when the past rightly refuses to release us from our historic obligations. The present confronts us with what remains to be done, and the future waits vigilantly to see whether what we say, that we mean what we say when we say only too often, never again. While we justly address the state and international organizations with our demands for rights, reparations, and representation, we must also enact the enlarged global ethic of neighborliness. Citizenship is crucial to our struggle for reparations. Neighborliness is no less crucial in preserving and propagating the ethic of everyday civility, without which citizenship in the public sphere, on the street, in schools, in hospitals, in public assemblies, in the media, is only a formal permit to coexist, not the right to belong. At its moral center, neighborliness is an ethic of care and caregiving, whether as human being, as citizen, or as public servant. And here I address in particular my colleagues from the FXB Center for Health and Human Rights, with which we are in a deep and convergent conversation today. Without caregiving in the fullest sense, without caregiving as part of the whole notion of security, without caring, civility soon turns into barbarism, despite legal protections. Caring demands a peculiar courage, a peculiar ethical courage to see yourself at once as subject and object, patient and agent, as the one who is a victim and the one who has survived, both at the same time. Caring is the ultimate respect for the singularity of each individual as neighbor, the acknowledgement of the unique urgency to deliberate on each case, and the essential concern for the complex and differential integrations that hold together the lives of groups and communities, citizens, and those who may not yet be given that particular classification. Let me end with one of the shortest and most beautiful poems I know on the ethics of care and caregiving, as a way of envisaging the neighborliness of self, other, and citizen. I have chosen this poem, which I think has a metaphoric resonance far beyond its immediate situation, as a tribute to the work of the FXB Center and a sign of how our involvements and engagements and commitments at the Humanities Center to starting a campus-wide conversation, a conversation within the community, a conversation at the crossroads of complex matters, fuels today, is the background and the foreground of our interest in this particular event and a longer collaboration with FXB. It's a poem by the great, great is such a bad word, by the sustained and brilliant poet Adrienne Rich, one of the leading voices for over half a century on issues to do with sexuality, citizenship, freedom, rights, without ever forgetting the deep internal, psychic, ethical structures, the deep inner struggles that we really need to confront and come to terms with when we speak, as we speak, of larger social issues, historic platforms, and larger moral declarations. She brings the voice of the deep psychic conflicts. She never neglects them. She always listens to the deep internal tensions that actually confront and engage with and think beyond the restrictions of community or territory or citizenship. And she is a great spokesperson for what I think, a great late spokesperson for what I believe to be the center of the notion of caring, civic caring, civil caring, global caring. If you know who has died on that bed, do you know who has survived? If you say she was weaker, held life less dear, expected others to fight for her, if pride lets you name her victim, and the one who got up and threw the windows open, stripped the bed, survivor, what have you said? What do you know of the survivor when you know her only in opposition to the lost? What does it mean to say, I have survived, until you take the mirrors that turn them outward and read your own face in their light? Our identification with the histories gathered around us today, with the lost voices that we hear today and that we join in our conversation on International Roma Day, depends upon our ability to recognize our collective fate as neighbors, as we acknowledge the vulnerability of ourselves as potential victims and one-time moral survivors. Thank you.
Good morning and welcome. My name is Jennifer Leaning. I'm the director of the FXB Center for Health and Human Rights, and it's a pleasure to see you all here. We have had now several conferences on the Roma. We, that is the FXB Center. The first one was in 2012, And the two co-sponsors for us at that time were the Mahindra Center for the Humanities. Homi Bhabha is always a dear friend and stalwart critic. And then the Gunsberg Center for European Studies. So we had two significant centers on this side of the river sponsoring something that we wanted to continue in a longer and more inclusive way that looked not just at the extraordinary, enduring, and bitter problems of the Roma, but also encompassed the many strands of suffering, collective injustice, and failure to deal with the injuries that we as survivors have inflicted on those who also have survived, but have deeper and more cruel memories of where they came from and where they actually are having trouble going. And I, along with my colleagues at the FSB Center, are physicians and human rights lawyers and people who've done human rights work in peacetime and in wartime and in chronic conflict, and deep states of oppression and stigma for some of their minorities. We worked in these contexts. And I, for one, have increasingly felt the paucity of what an investigation or a piece of research actually does. We managed to enumerate and to describe and attempt to explain and attempt to show where the roots of cause are for the suffering we are confronted with and attempt to describe. And we have this sense that, well, we'll come back to safer places like Harvard, and we will go to safer places like the polity sector in Washington or in Geneva. We will report what we have found. We will say, these are our recommendations. We'll ask people, will you do something about it? And I mean, I've been doing this for 30 years, and a number of people in this room have been doing it for longer than that, and certainly for decades. And it is, perhaps it's the human condition to wait until all other avenues of appeal and recognition have been exhausted to come up with a proper path forward. I feel we're close to exhausting a lot of the paths that a number of us have been on, and I don't see a resolution or coming to terms with what has to come next. So this conference now, which in our limited focus at the FXB Center began as an attempt to bring the problems of the Roma to public forefront, has now evolved in thinking, under the leadership of Jackie Bhabha, our Director of Research, has evolved into becoming one where we wish to include a wide variety of voices around other histories, other populations, most of us actually, who share histories of collective trauma, and to some extent or another have many, many issues that we wish to discuss in terms of how do we take these memories and move forward to do nothing less than change the world's acknowledgement of suffering and injustice. So that's a tall order. You can see by this sort of complex and dense brochure that we have a lot of superb people who are going to be talking on panels and giving keynotes and serving as discussants. And we have a packed day. My role here as I introduce and we move to the first formal part of the morning is to thank our co-sponsors. I said that in 2012 we had 2 powerful co-sponsors. Now we have 10, of course, including the Center for European Studies and the Mahindra Humanities Center, but also many others, and you can see them acknowledged both in the logos and in the text of the program. And I would also like to say that we have a number of fabulous people and staff at the FXB Center who work with us, extraordinary support from the Mahindra Humanities Center, and would like to ask you now, as you go through this panel, and set of panels and set of discussions, to think about really good questions you ask people. This is going to work only if you are really asking good questions of the people in front of you. That's going to spark them to be even more brilliant than they will in their initial presentations. And the second is to apologize in advance for the fact we're going to have to keep a fairly tight schedule, because there are many people here who have traveled across waters and continents to be part of this event, and we need to give each one of them ample, or at least sufficient time to say their key messages. So it is a deep pleasure to welcome you all here, and I hope you have an invigorating and sombering, but at the end, uplifting many hours with us. Thank you.
Good morning to all of you. My name is Arlen Fuller. I'm the Executive Director for the FXB Center. I do want to make one note before I start. Is certainly Professor Bhabha asked all of you to turn your cell phones off, and rightly so. But we do have 2 hashtags up for Twitter. So when you turn them back on during the lunch break or the coffee breaks, and you have a statement that resonates with you and want to share it, please use either the hashtag reparations or hashtag reparations for Roma, whatever would be appropriate. So I do want to join my colleagues in welcoming all of you to this wonderful event. This conference, as Jennifer has stated, marks the 4th year in which the FXB Center has recognized April 8th, International Roma Day, with an event that addresses the issues that the Roma community face, whether it be discrimination, social exclusion, hate speech, hate crimes. And in the past, we've hosted conferences focused on school segregation and hate speech. We've had a conference on the contemporary threats to the Roma and human rights. And we've also had a film screening on a documentary that was about the integration of an elementary school in Romania. And we see International Roma Day as a key component for what the FXB Center wants to do with our Roma initiatives. It's a tool in our efforts to advocate for the inclusion of Roma rights on both the academic and the policy agendas. And for those of you who are not familiar with the FXB Center work in this area, for the last 5 years, the FXB Center has been leading the work at Harvard on Roma issues with a program that utilizes research, advocacy, and capacity strengthening. And today we remain the only Harvard Center with a program dedicated to Roma studies. And we attract students and fellows from throughout the university who are interested in Roma-related questions. So when we began our project, our Roma program 5 years ago, we started partnering with scholars and organizations in 3 countries, in Italy, Romania, and Serbia. And we tried to better understand what sort of value added the FXB Center could have in such a long-standing, protracted problem. And now we can say that we've been involved in 9 countries throughout Europe, and we've found opportunities to advance discussions, introducing new topics that have been proposed into the policy debates relating to Roma, such as reparations, as well as advocating for the inclusion of the Roma experience in broader discussions here at Harvard and more generally in the United States. Research is also a major part of this program, and we have focused much of our work to promote the rights and participation of Romani children and adolescents by addressing unequal access to education, to training, and to employment. And in doing so, our team has employed what we call participatory action research. And we do so in order to provide a voice to the Romani community and to let them be involved and own and exercise their rights to seeing better change. For example, in Serbia, our longest standing project, We implemented a program to assess the education, employment, and civic opportunities, and to be able to identify the practices that can be scaled up to better improve the access to such opportunities. And we've then provided the evidence, strategy, and advocacy platforms to overcome those obstacles to empowerment. But by using the participatory approach that we've held as the core of all of our work, we've relied on Roma and non-Roma adolescents to partner with our research team and to design activities that foster community agency and ownership, instead of being the objects of research conducted by others, largely being a passive source of data and bystanders to the entire process. The youth are actually the primary researchers themselves with our team. So they're key contributors in the research design, active participants in data collection and analysis, and the interlocutors in the formulation of conclusions and the promotion of the findings that we have from our projects. So as a result, the youth-centered and youth-created questions that have been created have challenged the focus of conventional Roma-related research. And that research, the traditional research, which tends to view obstacles to educational advancement through a lens of economic deprivation and victimhood. Instead, this work has been able to, and this approach is focused on strategies for realizing community aspirations and looking at the demands that Roma adolescents have in making and realizing their education and employment opportunities. So through a combination of training, capacity building, research, advocacy, and community action, this project has improved the school-to-work programs and transitions for Roma youth in Belgrade, and has shed greater light on Roma adolescent engagement and the high interest that they have in breaking the intergenerational cycle of poor access to schools. And building on that success, we now are beginning a new project in Serbia, focusing on the 2% of Roma youth, 2% who make it to university. And while previous studies have focused on obstacles facing youth to getting into tertiary education, this study actually explores the success of students who get there and looking at the factors that promote that. And we'll identify Romani adolescents who, despite familial, historical, ethnic, socioeconomic disadvantages for there to be on that path, we're looking at those students who are the first in their generation, the first in their family to make it to tertiary education. But again, as this is a participatory approach, the additional goal of this project is to help empower students as role models and leaders within their own communities. A training component is also planned as part of the project, which would equip students with leadership tools and practical experience in dealing with community interests. So lastly, and relevant to today's discussions, in addition to our field research focused on empowerment of Roma youth, the FXB Center has also been working to inform and engage the broader academic community to support the efforts of Roma activists, communities, and institutions to combat extremism and hate-motivated violence. As many of you are quite aware, economic, social, and political developments in Europe have fueled a reemergence of violence against the Roma community, including state-sanctioned policies and practices, community attacks, hate speech, and hate crimes. And we're exploring the types of responses to collective injustice that are employed by different governments for the Roma. For example, when we've recently submitted a report to the UN Office of the Special Advisor to on the prevention of genocide, documenting the persistent patterns of violent attacks and actions against the Roma people in Hungary. Researchers at the FXB Center have gathered years of data identifying instances and patterns of violence, killings, military trainings, and propaganda against the Roma community. And I'm pleased to say that this report has actually been successfully employed by Roma asylum seekers to document persecution that currently exists in Hungary. So this is really the additional value of our work. It's bridging evidence-based research with policy advice and policy development. It's including students and partnering with other university centers in producing Roma research that can push the policy agenda. And this all culminates into events like the one we're having today, a conference in which academics, advocates, journalists, policymakers can further the discussion on human rights, equality, and justice. And with that, I am very excited to be introducing our next two speakers. First, I'd like to invite the main organizer of our event to speak with us now. Margareta Matake is a Roma rights activist from Romania. In 2012, she was awarded a Hauser postdoctoral fellowship at the FXB Center, where she currently works as an instructor. From 2005 to 2012, Dr. Matake was the executive director of Romani Chris, a leading NGO that defends and promotes the rights of Roma throughout Europe. During her tenure at Romani Chris, the organization took a stand against discrimination in landmark cases targeting the president, the prime minister, and the minister of foreign affairs of Romania. The organization's advocacy and litigation efforts have also contributed to the approval of the domestic school desegregation bill. Magda is also the driving force behind the FXB Center's Roma programs, and we're all very appreciative of the tireless work she's employed in terms of planning this conference and bringing us all here today. So with that, I'll introduce Magda.
Good morning. Thank you, Arlen, for your generous and kind comments. Happy International Roma Day. Baktalo Romanolve, Romalen. This year we observe two landmark anniversaries in the struggle for Roma rights. It has been 160 years since Roma slavery in Romania was abolished, and 45 years since the first act of worldwide political mobilization of Roma, the 1971 Romani Congress, was held. You may already know that on 8th of April that year, Roma advocates from different parts of the world agreed upon the basic symbols of our nation, including the flag and the anthem. They also told the world that they wanted to be referred to as Roma and leave behind the derogatory term gypsies, a request that was earlier made by a generation of Romanian leaders back in 1918. Many activists, though less members of our Roma communities, mark International Roma Day with cultural or remembrance events. They also take stock of policy accomplishments, and they propose new directions. So here I am now today joining them and take this opportunity to suggest two topics for our discussion. And I truly hope that we can advance them throughout the day. The first is the demand for reparations for Roma slavery. And this is a very personal and important topic for myself. The second is the issue of holding governments accountable when they enact or when they allow collective injustice against Roma. And both types of state-sponsored injustice, past and present, will be discussed today during the panels. So let me start with the Roma slavery in two former Romanian principalities, Moldova and Wallachia. After nearly 500 years of slavery, the Romanian church, the aristocracy, but also the Romanian state institutions, all of them slave owners, had inherited huge wealth based on slavery, including monetary compensations. But what did the Roma inherit? Losses on every side. After the final act of abolition in 1856, the 250,000 freed Roma slaves were given no reparations for the inhuman treatment they and countless of generations before them had endured. After 160 years, in nowadays, the fact remains the same. None of the descendants of Roma slaves in Romania have been granted any reparations, whether symbolic, moral, or legal. Looking elsewhere in the world, we know that reparations for slavery remains a highly sensitive and controversial topic. Many view it as radical, divisive, or outdated response to historical injustice. Governments are reluctant to engage with demands for reparations. They are, of course, they see the substantial financial implications for that, but they also avoid accountability and culpability for this past. Likewise, there are advocates, even among the Roma, who are a little bit hesitant about reparations for slavery. They see the potential interpretation of such a demand as being an opportunistic use of the past. But consider this. Through the Roma experience, although the Roma experience as descendants of slaves is similar to other groups who have advanced such claims already, so far the Roma have not participated in any international political advocacy asking for reparations for slavery. And even more so, the Roma movement has barely focused on this issue. And it will be interesting to hear today some of the speakers joining panels on Roma to share that. It will be interesting to hear their thoughts about reparations and why is that important or not. It's also my hope that speakers joining panel 1 will continue the conversation post-conference and join forces demanding reparations for slavery, for Roma, and for the other groups that were oppressed during slavery. But if we are to seek reparations for Roma, and we want to achieve an impact, I think that there are at least three joint actions that we have to look at. The first is acknowledging and recognizing slavery. For too many years now, we have been waiting and asking for public apologies from the state institutions and the Orthodox Church. And I think that after all, what is the importance of having February 20 as the commemorative day for slavery if the state institutions do not organize any public event acknowledging that that is the day for commemorating the Roma slavery? The second is taking responsibility for slavery. Financial, symbolic, and legal reparations, legal remedies are necessary. And the third is remembrance and public dissemination of the historic record through education. We need history books, we need memorials, we need museums, we need intercultural human rights education, and all of these are missing in most of the countries in Europe. But how we can move towards all these goals? Is it realistic to expect that government with the history of slavery will take the lead in acknowledging past guilt and offering reparations? Of course, that would be right and moral, but most of the time it's improbable. There are no precedents for such actions. Most reparation cases were pushed by advocates or by lawsuits. And I think for all these reasons, a key part of solution is for intergovernmental organizations to take the lead, to set up independent bodies and to seek for reparations for slavery. Moving on to the present, we come to my second emphasis, the current inequalities and discrimination facing Roma. We often explain them as consequences of historical injustice. That is partly right, but I think we need to more deeply explore the direct role that current state institutions play in committing collective injustices and overlooking them or failing to respond. Where there is a right, there is a remedy. But the vast majority of Romani children who have been or currently are segregated in schools in Europe have not received remedies of any kind. To date, no government has initiated a program to remedy the consequences of school segregation that has been a part of many generations of Romani children and youth lives. So who, if anyone, will be held accountable for the permanence of segregation? And I want to end on a more optimistic note. And I think it's fair to say that a new discourse is emerging from the Roma scholars and from the Roma leaders themselves. The Roma have started to question and to challenge government's ideas and government's policies towards Roma. A movement, I think, that it's starting to be seeded, one that is more critical, that has a more critical view towards the existing Romani policies, but also towards the existing Romani policies. And I think part of the new discourse and arguments that we want to build here is basically to question how to emancipate the non-Roma state institutions and citizens and scholars, how to help them change their attitudes, their ways of thinking, and their actions towards Roma. How we can ensure that a meaningful number of Roma participates in policy making, research design, teaching, and projects. I will stop here, but I will take another minute to take the opportunity to thank our colleagues and sponsors for making this event possible. I would especially like to thank to Steve, Sarah, and Neil from the Mahindra Center for all the help that they provided. Allow me to thank my colleagues at the FXB Center, Andrea, Cynthia, Erin, Krista, Hector, and Tizi made all this event possible. I also want to thanks to our volunteers, Riona, but I want to thanks to Ellen as well for all the support that she gave us for this. And finally, I want to thank Jackie Bhabha for her belief and her trust in this idea of reparations and its importance for many communities out there. And thank you, Chad and Evelyn, for giving us the opportunity to show the Romani Rising project on the screen. For those of you who are interested to hear more about it, both Chad and Evelyn are there. Thank you so much.
Thank you, Magda. It is now my pleasure to introduce our keynote speaker, Alondra Nelson. Dean Nelson is an award-winning American sociologist and writer from Columbia University. At Columbia, she has directed the Institute for Research on Women, Gender, and Sexuality, and is now the inaugural Dean of Social Science and a professor of Sociology and Gender Studies at Columbia University. She's also the founding co-director of the campus-wide Women's Gender and Sexuality Studies Council. She is the recipient of Mellon, Woodrow Wilson, and Ford Fellowships, and has been a visiting scholar at the Max Planck Institute for the History of Science and the Bio Center at the London School of Economics. She has authored a number of books: Body and Soul, The Black Panther Party and the Fight Against Medical Discrimination, Genetics and the Unsettled Past, The Collision of DNA, Race, and History, and Technicolor, Race, Technology, and Everyday Life. Her most recent book, and the book that she'll be discussing with all of us today, is The Social Life of DNA, Race, Reparations, and Reconciliation After the Genome. It's a book about the uses of genetic ancestry testing in the Black communities and how this new technology is enriching lives and changing perceptions of identity and connection to the ancestral homeland. And with that, I would like to introduce Dean Alondra Nelson.
Good morning, everyone. It's a pleasure to be here, to have this opportunity to speak with you, and in this very interesting and exciting transnational and comparative context that I certainly hadn't imagined when I was working on this project. And indeed, I'm going to talk to you today about the use of ancestry, genetic ancestry testing, and a historic case for slavery reparations that is the result of, that comes out of a decade plus of research, but really began as a project about racial identity and genetic ancestry testing. You know, the idea of the social life of DNA very much comes from the ethnographic experience of thinking I was doing one thing, a project on asking questions about genetic essentialism and racial essentialism and identity, and ending up with a project that looked at the myriad social and political uses of genetic ancestry testing in ways that surprised me. So every Black generation has its reparation struggle. Collective memory of chattel slavery in the larger public, if not in Black communities, grows dimmer as the years since emancipation pass. But the drumbeat for restitution, for amends making, for the intergenerational devastation wrought by racialized human bondage persists, pounding with renewed intensity in each decade, bellowing against historical amnesia. Across time and space, this song for reconciliation has rung out, and each generation finds its own key, changing register in the hopes of succeeding to be heard, because the voices of its ancestors were not. By the end of the 20th century, the double helix had become an unlikely chord in this call for reparations. For a community historically wary of genetic science, this development was quite unexpected, something like a blue note. The genetic zeitgeist is sweeping. Our DNA hopes are more boundless than we fully apprehend or dare to admit. In 2004, a geneticist named Rick Kittles, whose ambitions for genetic ancestry testing always included a measure of social justice, found his one-year-old company's techniques engaged in an effort to obtain slavery reparations. African ancestry's matrilineal and patrilineal DNA analyses were engaged as 21st century tools that might offer new leverage in the long-waged battle over the repayment of a debt now 4 centuries overdue. The social life of DNA in this instance expanded beyond the narrows of medicine, forensics, and ancestry, recombining these areas for a new political purpose. This effort continued a long history of endeavors to accomplish reparations for the lost wealth, wages, and culture of African-descended people that was the modus operandi of chattel slavery. The 2002 class action suit for reparations for slavery extended a centuries-long struggle. In the immediate antebellum period, the federal government acknowledged that a debt was owed to newly emancipated Blacks who had worked in bondage without pay. The debt, to use reparations activist Randall Robinson's succinct phrasing, begins to accrue with the arrival of the first enslaved Africans at Jamestown, Virginia in the 17th century. A plan for reparations was put in place by the federal government in 1865. Today's protracted struggle for slavery reparations was inaugurated with the callous breaching of a social contract. At the close of the Civil War, General William Sherman issued Special Field Order No. 15, a directive that set aside a large swath of land confiscated by the federal government from Confederate soldiers, including portions of the southern states of Florida, Georgia, and South Carolina. This land was to be divided into 40-acre segments and redistributed to newly emancipated slaves, some of whom had fought in the Union Army. By the summer of 1865, some 40,000 freedmen and women had been settled on 400,000 acres of Sherman land, and plans were in place to distribute another 450,000 acres of land as restitution. Accordingly, the refrain that emancipated men and women were promised reparations in the form of 40 acres and a mule for the discounting of their humanity and their lost wages would soon and for long after travel in African American communities. Yet within a few months, African Americans' march toward recompense came to an abrupt end. In September 1865, following the assassination of President Abraham Lincoln, newly elevated President Andrew Johnson overrode Sherman's order and commanded that the land allotted to freed Blacks be returned to Confederate soldiers, who would be pardoned in exchange for pledging their allegiance to the United States. This White House decree, called Howard's Circular 15, was drafted by and named for Freedmen Bureau's Commissioner Oliver Otis Howard, to whom would fall the task of seeing that this prejudicial policy reversal was carried out. Howard's change of duties was a bitterly ironic development because the Freedoms Bureau that he ran was now asked to implement the disenfranchisement of the very Black Americans it had been created to aid and support. From the very beginning, African Americans challenged this breach of contract. Historian Eric Foner recounts the rueful scene at a meeting in South Carolina where Howard was dispatched to explain the policy change to formerly enslaved men and women who were recipients of 40-acre parcels of land. Quote, "When Howard rose to speak to more than 2,000 Blacks gathered at a local church, dissatisfaction and sorrow were manifested from every part of the assembly. Finally, a sweet-voiced Negro woman quieted the crowd by leading it in singing spirituals. When the freedmen fell silent, Howard begged them to, quote, lay aside their bitter feelings and become reconciled to their old masters, close quote. He was continually interrupted by members of the audience who said, no, never, can't do it. Why do you take away our lands? As this account conveys, Howard did not only announce the end of the reparations plan, but also recommended social Black backsliding, suggesting that free men and women be reconciled to their old masters, a suggestion that was quite the opposite of the racial reconciliation that was desperately needed in the wake of a fractious war and an economy based upon human captivity. Adding insult to injury, Howard mandated that a committee of recently emancipated Black men devise the process by which they would be divested of their land. The Black men asked to join this committee voiced the deep sense of betrayal felt by their communities in a formal complaint, quoting here again from Foner. We were promised homestead by the government. If the government, having concluded to befriend its late enemies and to neglect to observe the principles of common faith between itself and us, its allies, in the war you said was over, now takes away from all the right to soil they stand upon, save such as they can get by again, working for your late and their all-time enemies, we are left in a more unpleasant condition than our former. You will see that this is not the condition of really free men, close quote. The government's abandonment of its reparations policy left African Americans in this more unpleasant condition of destitute poverty and subjugation to both those who enslaved them and to those with whom they fought in supposed solidarity. This betrayal did not go unchallenged. In subsequent decades, the outrage voiced here would gather intergenerational force, becoming a peculiar bequest passed down from descendants to ancestors. The African American reparations movement was born from this acrid cauldron of disloyalty and disappointment. A novel genetic reparation strategy was born out of an acquaintanceship between the African-American geneticist Rick Kittles and an African-American lawyer named Deidre Farmer Pailman. Farmer Pailman became familiar with Kittles' work on the African Burial Ground Research Project in Lower Manhattan that included his molecular genetic analysis of the remains of enslaved Africans in colonial New York City that became cited at Howard University's Montague Cobb Anthropology Lab. The two would meet, Kittles and Farmer Pailman, as graduate students at George Washington University in the mid-1990s. Kittles was completing a doctoral degree in molecular biology. Farmer Pailman was working towards a master's degree in political management. Soon to be known as the Rosa Parks of the reparation litigation movement, Farmer Pailman would conceive of a legal plan for restitution for slave descendants that highlighted the connection between inheritance and genealogy and would employ DNA to draw these links. The introduction of genetic ancestry testing in the historic case Farmer Pailman versus Fleet Boston, a first lawsuit for reparations, was a strategy tailored to the contours of the case as it moved from lower to higher courts. Yet this maneuver was also consistent with the growing utility of genetics in contemporary society. Indeed, the use of DNA evidence in this case had two prior necessary social touchstones. The first was the use of genetics at the end of the 20th century in an array of efforts to rectify past injury to social groups and communities. Forensic inquiries in post-junta Argentina, post-apartheid South Africa, and elsewhere married genetic technology and justice claims and were carried out under the banner of international human rights, of an international human rights framework that would be adopted by American-based, US-based reparations activists. While in the US, there was also at the same time, and secondly, growing awareness of the successes of the Innocence Project, a nonprofit legal advocacy organization established in 1992 that uses DNA evidence to liberate wrongfully convicted persons, including many African Americans. These high-profile exonerations turned the tide of many Blacks' aspirations about genetic science, and this came out in the interviews that I did with genealogists over the course of a decade. As a genealogist that I call Pat said to me, who had worked as an analyst in a crime lab, quote, "I've seen people let off jail sentences based on DNA. I'm not questioning about DNA. Given my experiences, there's no reason to doubt the technology," close quote. Although she had a privileged vantage, Pat articulated what so many African Americans expressed to me about the promise of DNA to set Black people free, literally and figuratively. Lending a heroic cast to genetics, the Innocence Project offered the double helix as a winding path toward justice and not merely an invidious back toward eugenics, as the sociologist Troy Duster puts it. But this later outcome remained probable. The expansion of genetic analysis and the criminal justice system at around the same time threatened to double down on the discriminatory practices that have yielded the largest and most disproportionately Black and brown prison population the world has ever known. Criminal genetic databases swelled as a wider range of contact with police, from stops to arrests, brought the possibility of having DNA collected in the state by the state. Having the possibility of having DNA collected by the state, not only of suspects, but also of their family members. For good and for not, this post-genomic moment has accomplished the foregrounding of genetics as a lexicon for race politics. DNA analysis waxed as a new language of social justice as the efficacy of civil rights claims, many argued, was waning. Concurrently, reparations politics, the historian Martha Biondi argues, offers, quote, "an innovative and compelling way to move beyond inadequate and besieged civil rights discourses," close quote. Why not then try to use genetics to bolster racial and social and economic justice claims? DNA is today being applied in practices that I term reconciliation projects. Genetic endeavors aimed at variously ameliorating the injurious repercussions of the past. We now turn regularly to genetic testing to unravel mysteries and resolve questions of all kinds. With reconciliation projects, DNA analysis is incorporated in attempts to reunite formerly opposed parties or formerly unified ones, rejoining broken ties within a family, a community, a nation state, or a diaspora. It's used to uncover biographical and historical information that has been lost to the march of time, or to adjudicate contentious issues. These efforts and endeavors to repair damage caused by fractious social and political struggles are undertaken in many arenas, including courts of law, laboratories, social justice organizations, and museums. Reconciliation projects are a form of social practice that happen across the globe. In post-conflict Argentina, in the well-known case of the Asociación Civil Abuelas de Plaza de Mayo, Grandmothers of the Plaza de Mayo, for example, genetic analysis has been used for more than 2 decades to help reunite children with their lost parents, who lost their parents to political violence and were unlawfully placed with adoptive families, to return these children to their biological grandparents. In post-apartheid South Africa, DNA analysis has helped to identify the bodies of former members of the African National Congress who were disappeared in the fight against state-sanctioned racial discrimination. While these efforts are very different, what they share is the use of forensic science, of genetic analysis, to elicit information about the past, often after conflict or trauma. And of course, this is the case as well, as I'll describe with this slavery reparations case. With reconciliation projects, genetics has been annexed on to long-standing, unresolved, and therefore persistent debates about belonging. Beginning with the emergence of humanitarian genetics in Latin America and moving forward to founding family and historical racial controversies in the United States, developments in the 1990s combined to make possible a new course for molecular biology, one set toward racial reconciliation. In March of 2002, now an attorney, Deidre Farmer Pailman, became the lead plaintiff in Farmer Pailman versus Fleet Boston, a class action suit coalesced from several individual cases in which the corporations were sued by the descendants of slaves for the return of lost wages and consequently lost wealth. Farmer Pailman's attorney, Edward Fagan, who had previously successfully obtained a settlement of $2 billion from Swiss banks on behalf of Holocaust victims, filed a complaint and demand for jury trial in a New York federal court on behalf of his client and, quote, all other persons similarly situated. The case was against Fleet Boston, Financial Corporation, Aetna, CSX, and 18 other subsidiary entities to be determined that profited, and 18 other entities as well as subsidiary entities to be determined that profited from the slave trade. In their filing, the plaintiffs sought a national apology to the descendants of slaves and financial reparations from these corporations in the form of large trust funds that could be used for social welfare programs to improve housing, education, and health care. The case was heard in late 2003 by the District Court of the Northern District of Illinois, but was discharged in January 2004 when the court granted the corporate defendant's motion requesting a dismissal. Though primarily based on the plaintiff's, the court primarily found the plaintiff's case lacking in the area of the legal doctrine of standing, although it was based on several grounds. Asserting that the plaintiff class did not have a precise or even proximate connection to former slaves, and thus could not sue for injury of their descendants, District Judge Charles Norgal noted that the plaintiffs cannot, this is a quote, the plaintiffs cannot establish a personal injury sufficient to confer standing by merely alleging some genealogical relationship to African Americans held in slavery over 100, 200, or 300 years ago, close quote. With this line of reasoning, the court contested the plaintiff class claim of hereditary standing or a demonstrable relationship to former slaves. The plaintiffs sought to counter Judge Norgal's assertion that they, quote unquote, merely alleged a genealogical relationship to enslaved men and women, and to persuade the court of their hereditary standing with scientific evidence. In March of 2004, Farmer Pailman and the 7 other plaintiffs filed a second narrower reparations case against Fleet Boston, Lloyds of London, and R.J. Reynolds that they claimed, quote, had aided and abetted the commission of genocide, close quote, by providing insurance and financing for slavers. In this suit, the plaintiffs responded to the court's argument that they lacked standing to bring the reparations case with genealogy results. A few months before, Farmer Pailman visited the African Ancestry Company's offices in the District of Columbia. This is the genetic ancestry testing that would be started by Rick Kittles and his partner Gina Page in 2003, and was one of the first 4 genetic ancestry companies to start in the United States, and one of the 2 remaining from this early period. Gina Page, the co-founder of African Ancestry, recalled to me how this visit took place. Quote, Farmer Pailman called and we made arrangements. She came to the office. This was early on in the company's first year, and she was definitely working on reparations. I remember Deidre explaining her work and the relevance of ancestry and the vision that she had for reparations, close quote. Rick Kittles, the company's chief science officer who had analyzed the test, recalled, quote, before I left Howard for Ohio State University, we did the test of Deidre Farmer Pailman and the other plaintiffs. And she was one of the first to talk about using the test as a prerequisite to prove your authenticity, to suggest that you could receive reparations, close quote. Analyses provided by the African Ancestry Company linked each of the plaintiffs to an ethnic group or nation state on the continent of Africa. While genetic ancestry analysis has been used in family and criminal courts, this would be the first time it would be used in a civil suit of this type. Genetic ancestry test results associated Farmer Pailman with the Mende people of Sierra Leone, inferred another plaintiff to be associated with a group in Niger, and inferred the association of a third plaintiff to the Gambia, among other contemporary locations on the African continent. These 8 genetic ancestry test results were submitted as an evidentiary retort to the standing doctrine. The DNA data, the plaintiffs argued, confirmed their hereditary connection to enslaved Africans brought to the U.S., and thus was also evidence of their legal legitimacy as aggrieved parties that should be recognized by the court and compensated by the corporate entities that profited from slavery. In March 2005, in a second lengthy decision, Judge Charles Norgal dismissed the plaintiff's second case, once again primarily on the basis of standing. Maintaining that genetic genealogy tests did not sufficiently establish a relationship between deceased slaves and the signatories to the class action suit, Judge Norgal noted the strengths and weaknesses of genetic genealogy as a hereditary evidence compared to other indices. Conventional genealogy is an effective way to show a line of inheritance between the plaintiffs and former slaves, the judge suggested, but this information can be difficult to come by, especially for African Americans. The one-drop rule, a more capacious strategy in which all persons of African descent might qualify for reparations, on the other hand, quote, and this is quoting Norgal, fails to differentiate between descendants of U.S. slaves and those of other nationalities with African heritage, close quote. Norgal's decision concluded that genetic testing, quote, is more promising than the above two methods, but alone is insufficient to provide a decisive link to homeland, close quote. Invoking the problem of the incomplete archive and the pernicious logic of hypodescent, Norgal concluded, in keeping with legal doctrine, that the only suitable means to establish a decisive link to homeland, using his words, was DNA evidence that could show an uninterrupted definitive line of ancestry from an exploited former slave to an aggrieved present-day descendant or descendants, and simultaneously a direct line of capital gained and lost from the accused corporation to expropriated laborers and their offspring. Genealogy test results, the court surmised, neither supplied the plaintiffs with genetic standing nor substantiated their hereditary injury. Thus, despite the established admissibility of similar forms of genetic analysis in other types of courts, DNA identification in this case was not efficacious, and the case remains undecided pending another appeal review. From this setback, one could conclude that genetic genealogy testing is of little legal value as a means of securing reparations. That is, it is a failed reconciliation project. However, the plaintiff showed considerable ingenuity in putting genetic genealogy to unprecedented use, just as the industry was emerging, and in so doing, opened new terrain for the struggle for restitution for slavery and a new type of racial politics. In the case of the reparations class action suit, there was the problem of hereditary or genetic standing, manifested as a gap between how the courts and the plaintiffs respectively interpreted relatedness. Tort law requires the succession of capital, matrilineage, and patrilineage to constitute a claim that is legally cognizable. That is, it demands an argument, that moves through narrow channels of legal logic rather than traveling through the broader moral currents of the infringement of human rights and the creation of a system, chattel slavery, that constrained a portion of the U.S. population as a caste, with the deleterious effects even into the present day that include the inability to make claims, specific claims often, about kinship. The reparations plaintiffs, on the other hand, introduced genetic genealogy tests into the litigation, not only to just demonstrate hereditary injury, but also to highlight the social death inherent in the chattel slavery system, which mitigates against their ability to have the evidence that they were asked to provide. Even though the plaintiffs in the Farmer-Pellman case ultimately failed in their bid for reparations, they may have gained ground in other ways. As reparations activist Conrad Worrell put it while awaiting the 2004 decision on the case, quote, history is being made regardless of what this judge does, close quote. Similarly, the noted sociologist Joyce Ladner agreed that even in failure, the case will have, quote, educated the larger public about the role that institutions played in slavery, close quote. And legal scholar James Davey put a finer point on this perspective, offering that the reparations case may be considered a success in the sense that it, quote, heightened awareness around issues beyond the confines of the courtroom and a wider social, legal, and political fora, close quote. To be sure, the debates about reparations, reignited by Ta-Nehisi Coates' essay in The Atlantic in 2014, can be seen as a passing of the baton to a new generation of intellectuals, and that this baton came from Farmer Paelman and her co-plaintiffs. And more to Davy's point, the erring in the court of popular opinion occurs in the context of the increased ubiquity of DNA, with the legal gatekeepers and the public alike being more exposed to the influence of genetics in numerous aspects of their lives. So although the case formally failed, and the task of making this case important for public fora, Farmer Paelman and her allies surely succeeded in keeping the drumbeat for reparations alive as generations before them had. Thank you.
Thank you, Dean Nelson, for your extremely insightful remarks. I think your comments that are linking the historical injustices and trauma to the contemporary movements and campaigns, as well as the potential for modern technology to be changing sense of identity and the ways in which we can all look at ourselves and advocate for ourselves. Is actually a fantastic way in which we can now frame the rest of today's discussions as the experts that we have throughout the day coming from various different perspectives can really lay out a much more thorough mapping towards what you've set as a foundation. What I'd like to do now is open it up to the audience for maybe 2, 3, 4 questions, depending on how detailed Dean Nelson wants to be. 3 questions. Okay, I've been told that we can't get to 4, so we'll see. So why don't we start? Sir, you were...
Bert Samuels from Jamaica. I'm an attorney. I argued a case in Jamaica in 2003 against the British Crown, and we came up on some obstacles. I'm grateful for your enlightenment about the use of DNA and genetics. And I think when we go again to court, we're going to arm ourselves with this new weapon that you have been enlightened me with today. And I'm happy to know that you're on the American front, we're on the Caribbean front in Jamaica fighting, and we won't give up. It's really a comment, and thank you for your great work. Thanks.
If I could just respond, I mean, it's a challenge. I don't know Commonwealth law, but I think it would be very difficult to bring it forward, even with more advanced DNA techniques. But I don't think it's the solution that you're looking for all sorts of reasons. But I'd love to talk to you more about that. Yeah.
Actually, let me see. So we have one question. Is there anyone else who wants to ask one more? Oh, so we.
Thank you, Alondra, for that wonderful, wonderful talk. So I have a question about, sort of the status of the DNA evidence as produced by African Ancestry organization. So they found out that these people were from, you said, the Mende, from Gambia and
The Niger. There were 8 different findings.
Right. Yeah. So was the judge not? He was not disputing their African ancestry. He's disputing
Correct.
The links between those places where these people may have come from, and a train of evidence. So that's the part that I hope you could say a little bit more.
Right.
So did he want a direct link?
Yes. Yeah.
From Niger to Jamestown, Virginia? There's not going to be one.
Right. I mean, so that's the impossibility of this strategy. That's part of the complication of it. And so, I think that I write a lot more about this, but the courts have been a vexed place to try to advance reparations in part because of the doctrine of sovereign immunity. The executive can't sue itself. And so this was, for the first time in over 100 years, an attempt to do something else and to try to use this genealogical strategy. And the genetic evidence, African ancestry, I mean, this was a year after this company had been introduced. So they were analyzing sort of 8 STR markers on mitochondrial DNA. And the technology's gotten more advanced, but even using what we have in 2016, I think it would be very difficult to provide the kind of specificity that they want. And part of the issue is that the reparations activists are really making a collective claim about, and a historical claim about social injustice, and the court recognizes only the liberal individual. And so you need to be able to provide that evidence. And indeed, what the court would have needed would have been a specific individual that we knew was enslaved, that had been transported from, Virginia to South Carolina on a CSX train, or enslaved by, Aetna or a previous subsidiary on behalf of a slave owner, these sorts of things. So it needed a kind of specific, and also genetic genealogy is really, the underlying epistemology is about populations. It's not about individuals as well, and the court really requires individuals. So one might be able to today take, genealogists now, or genetic genealogists are using third-party apps in which they upload their markers, and they can sort of look at their DNA tree, their genetic trees, and compare them with other people. So you can create, using genetic analysis, DNA trees in that way. So something like that might work, but the sort of preconditions for that, it would require, that other genetic genealogists open their trees to you, be willing to talk to you, and that's actually become very interesting and working with genealogists. So that's a long-winded answer, Evelyn, that the level of specificity required was much more. I didn't have the opportunity to speak about it today, but there's another higher court decision. That's the court that the conservative legal scholar Richard Posner's on. And Posner writes this wonderful response, actually, that effectively says, of course you're the descendants of slaves. Slavery was a horrible scourge. I mean, it's a kind of more empathetic rendering that you might expect from Posner. But in the end, it's like the evidence that we require is not borne out in this case. So the court didn't say you're not the descendants of slaves, but the court said, you can't prove it such that you can prove that you deserve restitution.
We have one more.
Thank you so much for your brilliant comments this morning. My question is regarding the case for reparations that Ta-Nehisi Coates puts forward. It seems to me that the research of genetic genealogists might be enlisted in the fight for reparations, which is rooted in Jim Crow injustices. And I'm wondering if you could talk a little bit about that, if that might be a solution to some of the barriers of the previous case that you described.
I'd have to think about that some more. I think not. I mean, with the power of, bracketing the limitations of the technology, and there are many, and there's lots of kind of historical leaps that are made. What they do well, even if when they're technically not as precise as we would want, is shine a light on slavery in the past, right? I mean, why genetic ancestry testing is important in part for many African Americans is that it allows them to say, in the face of people who say slavery was so long ago, it doesn't matter, get over it doesn't affect anybody like, actually, I'm using this test, and it's sort of telescoping back to a pre-Middle Passage identity, and I have to do it because this history doesn't allow me to have that information. So, the Ta-Nehisi Coates strategy is to get over that lap of that lacuna in the archive and that lacuna of information by moving things forward. And I'm not sure that genetics per se adds something to that. It's probably more helpful for this kind of longue durée argument for reparations.
Great. Well, thank you, Dean Nelson. Thank you, Dr. Matake. I think this has been a wonderful start to what is going to prove to be a fantastic day. Thank you.